Well, good afternoon, good evening, good morning. Thank you very much for joining us in this webinar where we'll be discussing competition law and policy approaches to digital platforms and ecosystems. I hope everybody is hearing me fine. I am Teresa Moreira, the head of the Competition and Consumer Policies branch of UNCTAD, and I would like to start by thanking our partners and co-organizers of this webinar, which are the BRICS Competition Law and Policy Center, the Brazilian Competition Authority, better known by its acronym CADE, and the Fundação Getúlio Vargas Rio de Janeiro, another partner from the academic world. We are very pleased to have a number of very distinguished speakers with us today. And I will not mention all of them right now, but I wanted to tell you that this webinar will start with the presentation of a recent BRICS report on digital markets that will be led by our colleague from CADE. And then it will be commented by scholars from different parts of the world, hopefully with some different views. So our colleagues from Japan and UK, so all three academics. And of course, we also will hear from another BRICS competition authority, the South African Competition Authority. And finally, we will also hear a presentation of an interesting project that is being developed by the BRICS Competition Law and Policy Center and the IASA Center based in Vienna. So I will hand over the floor to Nicolo Zingales from Fundação Getúlio Vargas. Thank you again especially to the speakers, but also to all the participants that are joining us here today. I wanted, before I close, just to draw your attention to a recent publication of my branch, of UNCTAD, Global Approaches, Global Competition Law and Policy Approaches to digital markets that you will find available in our webpage. And also to inform you that from the 3rd to the 5th of July this year, we will hold the 22nd session of our Intergovernmental Group of Experts on Competition Law and Policy in Geneva, Switzerland. And the agenda of this year includes a session on enforcing competition law and policy in digital markets and ecosystems, where we will also gather a very diverse and highly qualified range of speakers. And so I ask you to stay tuned, if possible, attend the meeting online. Thank you very much, and I wish all of us a very fruitful webinar. Thank you. Nicolo, over to you.
Thank you very much, Teresa. And I want to thank also UNCTAD for hosting us and for the great organization. Also acknowledge and thank the partnership of the BRICS Competition Center and CADE. I will be the moderator here. As Teresa said, my name is Nicolo Zingales. I'm a professor at FGV Law School in Rio de Janeiro. And I had the pleasure to work with CADE as a UNDP consultant in the preparation of this report that was mentioned by Teresa, which deals with competition law and policy in practice in a digital economy, focusing on the BRICS countries. And this is the output of the BRICS working group on the digital economy that was established in 2017 in Brasilia in a BRICS International Competition Conference. And the presidency of this group has been held by Brazil and Russia. And this represents one of the main products of the working group developed under the Brazilian presidency, following the first report that was published in 2019. Like that first report, it was based on a survey circulated with competition authorities of the BRICS and additional desk research. Just to give you a little bit of context of the report before we move to our discussion with excellent speakers that we have with us. The scope of this report was not specifically on digital platforms and ecosystems. It was more comprehensive. It was about digital markets in the BRICS. And so the question is basically whether one or more significant market players rely on digital technologies to produce or sell products or services, either digital products or services, or services and products that are distributed using digital technologies. So it is, by comparison, is not like the scope of the Digital Markets Act, which identifies specific platforms that are the focus of the regulation. It is more like the UK competition regime that was recently enacted, which refers to digital in a broad way. Because of that, it includes a number of practices and challenges relating to digital markets that are not only related to digital platforms. However, digital platform ecosystems are quite central, of course, in the scope of the report. There is not a lot of rehearsal of the characteristics of digital markets, which have been part of other reports produced in the past, including by CAGE in 2021. But the goal really with this report was to provide a snapshot of the challenges faced by competition authorities in these markets, with the aspiration to find some common grounds between the BRICS. So one of the first point that is acknowledged by the report is that there are different goals in each BRICS jurisdiction with regard to competition law. There is a common core that was identified in consumer welfare, efficient allocation of resources, and economic freedom. Some jurisdictions, 3 out of 5, include also choice and equality of opportunity as part of their goals. And we also saw China detailing specific goals for the platform economy, which include promoting a standardized, orderly, and innovative and sound development of the platform economy, while safeguarding the interest of the consumers and the public. And I emphasize innovative here because this was something that was introduced in a recent amendments of the Chinese anti-monopoly law. One of the also bottleneck in dealing with digital markets is market definition. And here in this report, the authorities concluded that the application of traditional tools of market definition is challenged by the tendency of digital markets to be highly innovative and dynamic, non-price centric, and interconnected, which refers to the concept of ecosystems as group of interconnected actors or services creating joint value for the consumer. So because of these challenges, the authorities are often led to adopting a less definitive posture with regard to market definition, placing more emphasis on market power. And for this, we saw a number of new indicators being developed that are mentioned in the report, such as the ability to unilaterally impose terms and conditions, including as a manifestation of superior bargaining power, which is explicitly recognized in South Africa, the possession of key data sets, and the ability to influence choice through online architecture and lack of transparency. On conducts, a common concern was identified, which will also be discussed during the webinar, which is the discriminatory conduct, exclusivity arrangements, and price parity. And all these are considered mechanisms that help increase market power, particularly in the context of digital platform and ecosystems. And here, given that the Competition Commission of India has unfortunately not been able to join us today, I'd just like to refer to their findings in an investigation of the practices of the main online platform for hotel booking called Make My Trip. which was originated due to concerns of exclusivity between the platform and some of the main hotel chains, parity condition, both of price and room availability, and predatory pricing. And here the company was found to be violating Section 4 of the Competition Act as a result of the conjunction of these practices, which, and I quote, create an ecosystem that reinforce its dominant position. So note that the term ecosystem is used to refer not necessarily only to the connection of different actors and services, but rather as a glue that puts together different conducts. This is similar to what the European Commission found in the Android case. And one can wonder in the future to the extent to which the emergence of the concept of ecosystem in competition practice will increasingly lead to a scrutiny of conducts viewed from a more holistic perspective, taking into account different markets and different manifestations. The next aspect that was identified as giving some common grounds between the authorities with regard to mergers, a broader concern for conglomerate mergers, which are more pronounced in the digital environments due to broader spillover effects across markets. And this means that there are more cross-market connections, particularly of complementarity, both on the supply and also on the demand side, which should be looked at carefully. This leads the authority to examine different kinds of tiers of harm, with special emphasis for portfolio effects and the acquisition of nation and potential competitors. The term ecosystem tiers of harm, which we'll be discussing today, has begun being used to characterize some of these mergers. For instance, the analysis by CAGE of the Microsoft Activision merger. However, some commentators contest these characterizations as giving rise to new categories of theories of harm that go beyond traditional conglomerate concerns. Finally, on remedies, it was acknowledged by the BRICS authorities that digital markets often demand a more proactive role by the antitrust agencies in maintaining and restoring a competitive scenario. For example, this can be observed in remedies that concern the creation of interfaces and the governance framework for interoperability and data portability or data segregation, as it happened in the Google Fitbit merger analyzed by South Africa, and the J3 ClickBus merger analyzed in Brazil, and also the Guia Bolso Bradesco conduct investigation in Brazil. And it was basically concluded that interim measures and voluntary commitments provide an advantage of speed and learning by doing in these markets, which explains why they're often being used. And in any case, the report concludes with a warning for appropriate monitoring and review of remedies, which is essential for effectiveness and deterrence. So this is a call for all of us, including researchers, to be more concerned with the practical effects of remedies and to recognize that in this complex field, we may not always get it right the first time around. So having provided this introduction, I'm very pleased to now kick off our discussion with an excellent set of speakers. So we have with us Commissioner Victor Oliveira Fernandes from CAGE, Mr. Hariprasad Govinda, Principal Economist of the Competition Commission of South Africa. We have Professor Masako Wakui, who is Professor of Law at Kyoto University. We have Associate Professor Denny Mazari from University College of London. Then we will have Associate Professor Maria Ioannidou from Queen Mary University of London. And this will conclude our first segment, which will be focused on country-specific perspectives on digital platform and ecosystem. Then we will check whether we have any questions in the chat. So I encourage you to submit your questions. And in the following segment, after we will address any questions left from this first segment, we have a presentation of the report from the BRICS Competition Center. So here we will have as speakers Alexey Ivanov, who is director of the BRICS Competition Law and Policy Center, as well as Elena Rovenskaya, who is program director at the Advanced System Analysis program of the International Institute for Applied System Analysis, who was partnering with the BRICS Competition Center in this report on ecosystem. And then we will have a final part for Q&A. So bear in mind that you can always raise questions, and then we will, in any case, record this session. It will be posted on the YouTube channel of the UNCTAD Competition Law initiatives. And also we will put up on the website the presentations. So be sure to circle back and check online the materials. So with that said, I think we can jump right into our discussion. So first of all, I will like to address Commissioner Victor Fernandez. I know Victor well, so I'll go by Victor. Victor Cade was leading the work stream of the BRICS Working Group on Digital Markets that produced the report, and dealt in the last couple of years with some landmark cases relating to digital platforms and ecosystems. And so we would appreciate if you could share with us some thoughts on what the authority identified as prominent features of these markets, and especially when it comes to exclusivity agreements and the effects of mergers involving large digital conglomerates. And if you could share with us, any lessons that you have learned through the practical experience of the authority in this field. So Victor, you have the floor. Thank you very much.
Thank you very much, Nicolo. So first of all, good morning, everyone. And I first would like to sincerely thank UNCTAD for giving us this opportunity to discuss some of the findings covered in this second BRICS report on digital economy that we have launched in the beginning of this year. And as Nicolo has said before, I think that the second report is very comprehensive and it's quite interesting to follow, especially because it provides a big portrait of the current state of play of antitrust enforcement in digital markets across the BRICS jurisdictions. And as Nicolo has mentioned before, it's interesting to see that we can see that there is a substantial convergence among BRICS jurisdictions in recognizing the importance of some substantive standards, such as the consumer welfare standards. But alongside with that, I think that there are some differences that are worth to highlight between the authorities, especially some authorities like Brazil, Russia, China, and South Africa recognize other goals, such as ensuring economic freedom or ensuring a level playing field for small and medium enterprises. And this goals can be somehow translated into more legal standards, more crafted legal standards for assessing abuse of dominance in this case. And also, as Nicolo has said before, the report discusses a range of behavioral and structural remedies that were used in some digital markets across BRICS countries. And so we have very interesting cases covered in Russia and in India. And regarding Brazil, we have handled with a few very interesting cases involving exclusive dealings in digital platforms. And so I have prepared for my intervention here today a brief overview about the main cases that we have discussed in Brazil in this regard. As Nicolo has mentioned it, over the last years, Kaji has focused it on tackling some forms of abuse of dominance, not only involving big global platforms, but rather some very large regional platforms in Brazil and in South America as well. And in these cases, we had the opportunity to try to make commitments and other interim measures that could balance and try to restore the competition in the markets involved without giving away the possible efficiencies involved in this kind of investigations. So there are two main cases that I would like to highlight today, which the first one is the Gympass case, and the second one is the iFood case. The Gympass case was a case involving the Gympass company, which is the largest Brazilian health club aggregator platform. So it is a very interesting business model. It's a platform that intermediates companies and fitness studios in order to give access to the employees of these companies the opportunity to use gyms and fitness studios as well. So in 2020, a rival platform called TotalPass filed a complaint before CADE, claiming that the competitor Gympass have imposed large exclusive agreements on more than 80% of the gyms in Brazil, hindering the entry of new competitors. So CADE first adopted an interim measure prohibiting Gympass to establish new exclusive agreements. And in 2022, CADE has finally reached a very sophisticated cease and desist agreement with the company. And in this case, CADE has tried to reflect in this agreement the adoption of a more nuanced rule of reason approach for exclusive dealings involving digital platforms. So CADE has acknowledged that in this case, the market was prone to some kind of tipping because we have some very strong network effects in place. So CADE has tried to set some very detailed rules about how the company could about the limits that companies should follow in imposing these exclusivity clauses. So under the terms of the commitment that was imposed by CADE, the Gympass was prohibited from using or imposing exclusivity clauses or MFN clauses above a maximum level of the 20% of its base of gyms in cities, or to try to set some threshold in terms of market coverage for this practice. And on top of that, CADE has imposed that exclusive agreements involving these platforms should be somehow related to some forms of efficiencies based on direct investments made by Gympass in capital goods or gym equipments with the fitness studios. So that was a very interesting case. And the second case involved the iFood platform, which is the largest food intermediator platform in Brazil. CADE has acknowledged that by 2020, for instance, iFood holds around 80% of the market share in this sector. And of course, by imposing exclusive agreements, iFood could be able to foreclose the markets for rival competitors. And Kaji has reached a very similar agreement with this company, even though we are talking about very different markets here. Kaji has tried to draft an exclusive to draft a cease and desist agreement that would, on one hand, prohibit exclusive contracts below a threshold. But on the other hand, Kaji has tried to save the efficiencies involved in some forms of exclusive agreements in the sector. So under the terms of the commitment, Kaji has imposed that iFood should obey a maximum of 25% of the total sales volume in the platform linked to exclusive contracts with bars and restaurants. So as well, we have did in the Gympass case, we have tried to set a maximum of market coverage within the platform itself for avoiding it to type the market as a whole. And on top of that, Kaji has prohibited iFood of signing contracts with large chains of restaurants in Brazil, with chains with more than 30 restaurants in the country. And also, Kaji has set some very specific circumstances where exclusive agreements that should be transferred by the bars and restaurants involved in the platform. So these cases are very interesting because they show how by imposing new forms of remedies and new forms of commitments, Kaji is trying to reach a balance between how to assess under the rule of reason the potential anti-competitive effects of exclusive agreements in digital platforms. And I think that the cases are very, very unique in terms of how Kaji has tried to handle this. And to finish, I think it's important to touch upon the view that Kaji has been implementing in some mergers, in some high-profile digital mergers. So in 2020, 22 and 23, Kaji has also reviewed the Microsoft Activision Blizzard merger, and it has especially discussed in the case an ecosystem-based theory of harm by assessing whether the merger would increase Microsoft incentives to foreclosure its digital ecosystems to competitors in several markets. And ultimately, Kaji has cleared the merger by concluding that Microsoft would have no incentive to limit third-party games, as that would decrease the appeal of the Xbox system as a whole. So this was the first case that Kaji has tried to embrace a more in-deep ecosystem-based theory of harm. That was a very interesting exercise for Kaji in navigating these new forms of theories of harm. So I think that I have reached my time limit for now. But those are the main takeaways that I think are worthy to highlight, Nicolo, in terms of the Brazilian cases that we have handled over the last years. So, but I stay here, and I look forward to hear from our distinguished panelists their impressions about the other cases and the report itself. So thank you very much, Nicolo.
Thank you very much, Victor. It was a fantastic overview of these landmark cases. So interesting to see that exclusivity was a concern not only with regard to conduct, also with regard to the theory of harm in the merger context, and this aspect of not looking black or white, but trying to save the efficiencies and limit the extent to which the exclusivity could foreclose markets by introducing a cap. I think that's a very good illustration of how Kaji has learned through these instruments about the features of digital markets. Now, I would move on to another competition authority that was actively involved in the work stream of the BRICS working group on digital markets, and this is the Competition Commission of South Africa. Harry, Mr. Govinda, basically you participated. You were working at the authority during the period of the gestation of this report, and in this time we observed the authority first facing challenges of digital ecosystems in two merger decisions in early 2020s, and later on we saw notably the launching of two market inquiries into digital platform, one of which is still ongoing, as I understand. So it's definitely been fascinating to see the advances of the authority in this regard, and to see also how market inquiries provide the mechanisms to fashion effective remedies in dealing with a different type of players in a differentiated manner, well, we could call differentiated ecosystems in a different manner, to use a term that is the subject of this webinar. So yeah, we would like to hear, if possible, the experience of the authorities in those merger cases, and whether it was instructive in leading up to the decision to undertake market investigation or market inquiries, as you call them. Also, it would be interesting to hear how the target ecosystems for this inquiry were selected. I think it would be interesting for any other jurisdiction considering this type of intervention. So I see that the presentation is already up. I'll leave the floor to you. Thank you very much, Harry.
Thanks, Nicolo. Good morning, afternoon, evening, everybody. I'm going to take you through the South African experience on the digital ecosystem. This is a snapshot of the kind of cases and inquiries that the Competition Commission of South Africa looked into over these years. In the interest of time, I'm going to take you through only the highlighted ones. We have had a few market conduct cases, mergers, and also one of the cartel cases. The first one I'm going to look at is the MIH e-commerce and BRICS merger. Just to give you a bit of background, MIH e-commerce is ultimately controlled by Naspers Group, and it is mainly an investment holding company and does not itself supply any products or services in South Africa. So of relevance to the proposed transaction is its investment in OLX and the Naspers subsidiary car trader, which operates as Auto Trader. OLX is an online journalist classified advertising platform and carries advertisements for a broad range of goods and services listed on its website under a number of categories. Of relevance to the proposed transaction is the car category. An Auto Trader is a specialized online advertising portal which functions primarily to allow users to browse classifieds exclusively for new and old used vehicles. And I mean, I'll use MIH e-commerce, OLX, Auto Trader. We'll put them together. We call them the Naspers Group going forward, just to be simpler. And the primary target firm is BRICS, and it is active in the sale of second-hand vehicles. And the kind of theories of harm considered by the Competition Commission, including the removal of potential competition, self-preferencing, and the unfavorably using the data sets, economies of scale, and scope in advertising, apart from others. The first issue of the removal of a potential competitor arose when the Naspers Group had acquired stake in the Frontier Car Group. That was a Berlin-based startup company. And with this acquisition, Naspers Group intended to enter the South African market for wholesale and online business of cars from the public, utilizing the instant cash model and selling it to the dealers in direct competition to WeBuyCars. And FCG, as we know, is a credible player in all of the markets where it operates, and it had plans to enter the South African market, which was thwarted directly as a result of the merger. So we had run the removal of potential competitor kind of an argument. With respect to the exclusionary portfolio effects, we looked at numerous ways in which NASPers can harness the complementarities between WeBuyCars and Auto Trade and OLX to the exclusion of effective competition against WeBuyCars rivals as well as other platforms. And at the time of the investigation, we knew that WeBuyCars was considered as a large and dominant wholesale and online buyer of used cars. And on the other hand, Auto Trader was considered the largest online classified platform, which generates significant customer traffic, such that it is a key and important online platform for traditional used car dealers seeking to sell their car stock. So in the view of the Commission, that the merged entity will have the ability to leverage the significant Auto Trader position as well as OLX platform to exclude the rivals of WeBuyCars. And we also looked at whether it could enhance the Auto Trader's dominant position in the online classified vehicles advertising market. WeBuyCars can also dominate the market for the retailing of second-hand cars by dominating the second-hand car stock in the market through OLX and the Auto Trader model. And ultimately, this merger was recommended for a prohibition, and the Competition Tribunal also upheld the decision to prohibit. The second case I'm looking at is the Google Fitbit merger. Google does not require any introduction, but Fitbit also, you could be knowing what it does. But just to introduce, Fitbit develops, manufactures, distributes wrist-worn wearable devices as well as smart scales, software and services designed to give its users tools to help them reach their health and fitness goals. The main products available in South Africa are fitness trackers, smartwatches, and the mobile app, the Fitbit mobile app. Generally, the wrist-worn wearable devices are typically attached or paired to the smartphone using Bluetooth and through the companion app installed on the smartphone. To use a third-party wearable device, an Android smartphone user needs to pair this device to their smartphone, primarily using Bluetooth, and download and install the companion app to their smartphone via the application store on the smartphone. In South Africa, the Commission approved this merger with conditions upon a series of behavioral commitment by Google to be monitored by an independent trustee who will have the necessary skills, competencies, and technical abilities to monitor these conditions. The kind of theories of harm that we looked into are like Google will be able to exclude Fitbit's competitors in the market for wrist-worn wearable devices. It can degrade the functionalities of competing apps through the APIs, which facilitate the communication between the device and the smartphone. Google can also exclude the competitors of Fitbit or even frustrate the functionalities of the companion apps of Fitbit's rivals. Acquisition of Fitbit's database may also provide an important advantage in online advertising markets to Google to further entrench its dominant position. A combination of the Google and Fitbit database on individual data collected daily will create the ability and incentive to foreclose downstream competitors' access to data, which in turn used as an input in the markets for online advertising and digital health in South Africa. Google could also make it difficult for potential entrants to enter the digital health market if it starts collecting and using the health data required for it to enter the digital health market. And there could be various other ways in which it can grow Fitbit and make it a significant player in the collection of the health data. And this would allow Google to leverage its dominance into the digital health market and be able to price discriminate and extract significant surplus from the health insurance firms. To price discriminate in the sense that Google will be in a position to, with the daily collection of the health data, will be precisely understanding whether a consumer is risky in terms of health, how risky, high risk or low risk. If it can make that segmentation, it can easily price discriminate, charging a higher price to higher premiums to the high risk consumers compared to the others. So we thought this was one of the other theories of harm which could result as a result of this merger. Commission was of the view that this would significantly alter the market structure for the supply of wrist-worn wearable devices in South Africa, and it will increase barriers to entry for potential entrants in the market. In terms of the remedies, we looked at that Google must commit to make the core interoperability APIs available without charge for access, and also on a non-discriminatory basis, without discriminating first-party wrist-worn devices or companion app, or third-party wrist-worn devices or companion app. Google must commit not to degrade the core interoperability APIs by reducing their functionality to third-party wrist-worn wearable devices relative to the first party. Google further must commit not to discriminate against wrist-worn wearable device OEMs by withholding, denying, or delaying the OEM's access to functionalities of Android APIs. Google also must not use any measured body data or health and fitness activity location data in or for Google Ads. And Google will maintain access to users' health and fitness data to software applications through the Fitbit Web API without charging for access, and also with subject to user consent. So these are the two important cases that we looked into. But in terms of the online intermediation platform market inquiry, before this inquiry, we had conducted market scoping study into the digital markets. Although this inquiry is proactive engagement into the market, the COVID also assisted. When we looked at during the COVID time, there was a significant surge in the online transaction. So this was one of the first inquiry post the 2018 amendment, where the remedial actions are binding. And we looked into various streams, but I'm going to look at only two of the streams in the interest of time, which are highlighted. So first, I'll take you through the Google search. Google search requires no introduction, 90% of the search engine market. And it also leads in the e-commerce and travel accommodation segment, as it provides 60% of the traffics to those streams. And it is a critical gateway to consumers for all platforms. And its business model of paid search and key results favor large businesses. Both paid and organic search favors deep pockets. Google search engine result page features high concentration of clicks and duplications, and raises barriers to expansion for smaller businesses and reduces visibility. And it also has self-preferencing concern. And these are the key findings that we looked into, and imposed the following remedies. And these remedies are aimed at enhancing the visibility of South African SME and Black-owned platforms through giving smaller South African platforms 180 million rands worth advertising credits, investing 150 million in training, product support, and other measures for SME and Black-owned platforms, introducing a new platform site unit to display smaller SA platforms, and adding a South African flag identifier and search filter to enable consumers to easily identify and support SA platforms. And to address the self-preferencing concerns, Google will implement in South Africa the changes required under the EU DMA. And all of these remedial actions now have been in the process of implementation.
Right,
The second and last, Okay, so the second and last section I want to look at is the e-commerce. It's very similar to the Amazon. It has a conflict of interest arising from the retail division it runs, along with the marketplace. It also has narrow parity clauses in the agreement, and there are numerous complaints in terms of universal product gating, unfair use of the data, market power in terms of pressurizing the suppliers to give them preferable rates, buy box that favors their retail division, and there is a dispute resolution mechanism unfairly disadvantages the sellers. In terms of remedies, we wanted the segregation of retail division from its marketplace operations, and we also recommended removal of narrow parity price clause by Takealot, and it cannot enforce the product gating on its own, but from the suppliers. Takealot to introduce 60-day dispute resolution process for sellers' complaints on returns and stock loss. Takealot must reconfigure its buy box, not only to allow the fastest, but also the cheapest options for the consumers. And any large e-commerce player which would enter the market will comply with the similar provisions that are set out for Takealot. For the Black-owned businesses, we recommended prioritize onboarding, 3 months fee waiver, 6,000 ad credits, promotional rebates, and targeted campaigns for Black-owned business. Initiative to mentor, develop, and promote Black, female, and rural businesses. All the recommended remedial actions are in the process of implementation, and I stop here. Thank you, Nicolo.
Thank you very much, Harry. Fascinating development, and it's interesting to see these remedies that are not the same remedies that are being imposed elsewhere. So this concludes our BRICS perspective with a snapshot of what is happening in the country. I think there's a lot that can be compared and contrasted with other jurisdictions. I now would like to move to another legal perspective on developments regarding competition, digital platforms, and ecosystems, which is from a country that has done a lot over the past few years, and there is Japan. We have seen the Japanese Federal Trade Commission vigorously enforcing competition law against leading digital platforms, and we have seen the development of very interesting studies on advertising, data markets, and mobile ecosystems. The authority has adopted adopted a specific regulation called the Act on Improving Transparency and Fairness of Digital Platform. And there is a rumor that more intrusive or more extensive legislation is now being considered. So, Masako, we would like to hear, if possible, your assessment on these developments. Thank you very much for joining us. The floor is yours.
Oh, thank you. Thank you very much for having me. Can you hear me?
Yes.
Yes, good. Yes, it is an honor to discuss a very important issue at a very important event like this. I was requested to share my views based on Japanese experiences. I may not specifically comment on BRICS report. I mean, congratulations, it's great work. But may I ask a few questions based on my experience in Japan, but the whole presentation is inspired by it. So let me start. Well, the competition law in Japan, called Anti-Monopoly Act or AMA, regulates unfair trade practices, UTP, and abuse of super bargaining position, ASBP. Then you may think Japanese competition law is, well, good. Well, thank you very much, Nicolo, for the introduction. Well, kind of active indeed, but not as much as you would expect. I don't know. You will tell. But my view, because I hear very often that someone like scholars outside Japan tells me that you unfair trade practice. It must be all about fairness, and abuse of supervising position should be very good handy tool to deal with the issues various fairness issues arising with an ecosystem or caused by dominant digital platforms, then I would have to explain that the reality is more nuanced. Then I would like to, the topic I chose is discrimination, which includes self-preferencing, by which the digital platforms, the company who regulates the ecosystem, treats its own or affiliated companies' products or services favorably. So later we will hear about the BRICS report more, which covers this issue as well. Then here, well, although the JFTC has been active in many cases, but about this, Japanese record is almost empty. Well, it depends on the definition of self-preferencing, but when it comes to the EU, like the one that you presented, like Google's Google Shopping case, there is no JFTC case, no formal case. Then why? Well, I hope that I can manage to explain why by the end of presentation, but empty space and silence may speak more or may suggest something more, which is Japanese philosophy, but well, anyway, let me start. So basics, what is self-preferencing? So this is a, there are many ways to preferencing on the self, but if it's about the visibility, for example, this is Yahoo Japan, like general search engine, probably used by only in Japan nowadays, but here you see the card payment method. If you click on this, you see this PayPay card, and both actually this Google, Yahoo, I mean not Google, sorry, Yahoo Japan search engine and PayPay card are both served by the provided by the same company. Japanese, I'm glad to hear that some the regional big tech. Here's the one, Japanese big tech, Japanese IT tech company, Z Holdings. So means that you see this here, kind of preferencing this payment method, this PayPay, than compared to the others. So this could be like leveraging one strong position to gain competitive advantage in another market. So this is kind of self-preferencing. The next question is, should we regulate this or not? I think it is difficult question, even after Google EU, Google Shopping, even if this is the, it may be clear leveraging case, but I personally think that it remains difficult. So to what is wrong with pushing its own products and services? And supermarkets have been engaging in this for a long time, and is this kind of regulation economically sound? And under what conditions it should be regulated? Well, one may say that self-preferencing should be regulated only when it is done by dominant company, and it is okay for someone like Yahoo Japan to do this, as it has only this much, little more than 10% market share. While the other may argue that given that many, particularly senior citizens, do not multi-home in relation to the search engine, and then Yahoo Japan could be a gatekeeper, or thus should be regulated. Then if self-preferencing potentially like several harm should be clear, like leveraging, if that practice poses such question, it can be even more trickier to tell whether discriminated treatment or differentiated treatment, which does not involving does not have self-preferencing aspect, should be regulated under the competition law. So in Japan, here's a debate. This is a debated issue, as there is a civil case Tabelog. Tabelog is the most popular eating place search and reservation platform in Japan. The restaurant, or in this case, this cafe, is shown like this. Then the unilateral and allegedly unexpected change to the ranking algorithm, scoring and ranking algorithm, I mean, is the issue in this case. Well, this is not a real case, and this is only for the illustration purpose only. In the real case, plaintiff is not a cafe anyway; it was a restaurant. But suppose that before before the change, that cafe had high visibility like here. However, after the change, it's ranked here, right? I don't know, it's like 31 first pages. So much bad. So its visibility significantly decreased, while other similar cafes remain, let's suppose that other similar cafes remained unaffected that badly. So here's the differentiated treatment. So is this wrong? And why can't be theory of harm? And is such harm qualified as something that the competition law should care? So this is a non-exhaustive list of potential harms. The demotion could serve as a penalty for the cafe and restaurant that didn't adhere to exclusivity condition or requirements. If exclusivity itself is unlawful, any practices enforcing that should be problematic. So this is easy if this is the theory or harm that we are looking at. Or second, the demotion is to make the listed restaurant to pay some advertising fee. Well, let me explain this. Like the Tabelog gives the higher ranking to paying restaurant. Then Tabelog may have wanted to get this promotional fee by demoting some restaurants to earn this money. So in that case, this is wrong. This is what the Competition Authority of Japan Fair Trade Commission, JFTC, said in a report. Then, but the Tabelog is not the case. There is no, that such fact was not found in this case. Neither this exclusivity is involved, neither to solicit advertisement. Well, what about the distort competition amongst the restaurants and the cafes, or discrimination per se? It's unfair, so it's bad, or some special responsibility or fiduciary duty or that kind of violation, or to protect customer user experience. What is the harm to? In the end, the plaintiff has lost at the High Court. None of this has accepted, but I will explain it later. But like this, when it comes to the this, I think that this discriminatory treatment in relation to visibility or ranking and ranking algorithm is a challenge for the competition law, I think, in general. Yeah, so let me then even more difficult when it comes to justification, how if we accept certain, even if we accept certain theories of harm, what justifications can be provided? So clearly, we really need to clarify the goal of the competition laws before we discuss these practices, as the BRICS report rightly have done. But particularly on top, additionally, some underlying principle, what kind of, well, is that, well, for example, the concept of special responsibility of the dominant company, do we accept that concept or not? Well, Japan does not accept it, in fact. Or other like principle or core, at the core, whether do you have the EU style abuse regulation or the US style monopolization regulation? So that makes a difference when it comes to the facing that how to assess the real case as well. Yeah, so Japanese law, finally, and so let me briefly explain how does Japan approach to the issue. Well, under the competition law, as I said, there has been no JFTC case in which the Google shopping case like self-preferencing in relation to the visibility was found unlawful. In relation to the discriminatory treatment, as I suggested, well, generally, Japanese competition law is very cautious or reluctant to find a violation. Well, and that is despite the AMA's prohibition of unfair trade practices and abuse of super bargaining position. Well, let me explain why. Well, first, what is VP to begin with? And what is it? Right, company like this, right, with a super bargaining position can abuse their power and harm their trading partners here, trading parties. Such abuse can distort competition, placing mistreated partners like here at disadvantage compared to those not subject to the abuse. So thus, the ASPP regulation can be a very handy tool to deal with unfair discriminatory treatment, whether or not it is also a self-preferencing. And it may be indeed the case in Korea where the UTP and the ASPP regulation are actively, or sometimes aggressively, enforced by KFTC. But in Japan, the GFTC courts and scholars have been cautious not to make the ASPP regulation overreaching. A reminder is the ASPP regulation in Japan was implemented in 1953, well before digitalization, and when Japan was trying to catch up with the US and the European countries. So the concern about overregulation or even concern about protectionism using competition law to protect Japanese companies was often expressed by the US and economists, in fact, and which was being taken very seriously. So that, and against that kind of backgrounds, so in Japan, ASPP regulation tends to focus on specific types of practices, such as like this, coercive sales or requirement to pay sponsor fees and like this, like as outlined, they are actually comes from this provisions of the AMA itself. And in Korea, ASPP is enforced in totally different manner. So you don't see this self-imposed restraint, but yeah. And in the guidelines, if you look at the JFTC guidelines, this whether or not the disadvantage could have been calculated in advance or not has been critical factor in finding an ASPP in the decisional practice, as far as I'm concerned. And in the violation, where the violation is found, there are also clear imbalance in rights and obligations as well. So yeah, like abusing party requires a counterparty to pay money for nothing. So this, yes. So I have to wrap up.
Yes, just I know you want to mention the new proposals and regulations, so if you can briefly give a highlight.
Okay. So like this. So the AMA this way very limited. So for this reason, Japan needed some special act tailored to the digital platforms firms that when it comes to digital transparency, this is the first. But what this law says, like be transparent and to ensure mutual understanding, and it could be fine, it could be good, but if the market is tipped and if the digital platforms really has a dominant position, I don't see that to what extent this would serve to restore competition or fairness. So there's a limitation clearly. So here's as Nicolo said earlier, here's the bill. And now it's assessed and soon it will become law. So this is about the only target App and Google, so, and only relates to the smartphone. Then also the coverage, like self-preferencing, that is many provisions, but basically they are about self-preferencing that's prohibited. And some other obligations, but they're very limited in scope. But yeah, so the question is that enough? Well, some may say that they may want to have more stringent coverage, more broadly covering legislation even further, but let's see. And even that, as I said earlier, self-preferencing alone is could be a challenge given the big tech existing, particularly outside Japan. So let us see. Then let me stop here. So for the sake of the interesting time, thank you very much for your attention.
Thank you very much, Masako. It's super interesting to hear about all these different approaches. So first, abuse, superior bargaining power regulation, and then specific, more targeted regulation to digital platforms. And we'll see if that is enough, as you concluded. Well, that now, in the interest of time, I would switch immediately to our next speaker, which comes from the United Kingdom, or at least is based in the United Kingdom, which is the first jurisdiction that published basically a report on digital markets, the famous Furman report that initiated all these discussions, and recently just adopted, the ex-ante regulation with the digital competition regime. So we have seen the CMA active in parallel with many cases, and also market inquiries, and being particularly receptive of theories of harm that concerned digital ecosystems in some way. So this was the case, for example, in Microsoft Activision and Amazon iRobot. And I was wondering if our next speaker, Danny Mazzari, Danny, how have you been looking at these developments as an academic of one of the leading centers of competition law and policy? We look forward to hearing from you. Thanks for joining us, and you have the floor.
Hi, Niccolo. Thank you. Thank you very much for this kind invitation, and Teresa and Akari Yamamoto. It was a pleasure meeting you all in person last December, and a pleasure to join you virtually here today and see how these ideas have materialized. So I thought to cover broadly the EU-UK perspective and recent developments relating to ecosystems, as we discussed in the context of merger control. But if there is time, and later on with my fellow commentator Maria and Ido, also based in the UK too, if there is time to focus more on the ex-ante framework. But for the time being, let me share my screen on the my slides.
I don't know if you have been given the status of host, therefore you might now. Yes, now you have been, so now you should be able to share.
Let me. Okay, I think I've got this right here. Okay, is this clear?
Yeah.
Is this visible? Perfect, thank you. I thought I should start maybe with a very helpful snapshot of where we stand in theory, actually, with the concept of ecosystem. So very briefly, it's a concept that originated in economics and business management literature, now slowly being translated in the legal sphere. Ecosystems, as understood in the business, mostly management literature, are comprised of multiple independent actors. But what is, I think, very interesting, and it explains also regulatory intervention, is that they have this feature of joint value creation. So the focus is not just the individual transaction between actors in a competitive marketplace, but the joint value creation, which creates in turn very strong interdependencies between the ecosystem members. So you can think of a mobile ecosystem and its business users, app developments, right? Being also the various members, independent actors. So they all have an incentive to maximize the pie, right? And this also creates competition between actors within the same module, as it is called in the business management literature, rather than markets or in nascent emerging modules. So they are in a relationship of co-petition, as PT&TC have underscored. So the importance is bigger than the sum of the values of different parts. Now, members of the ecosystem, they rely not only on their price mechanism to coordinate economic activity, but they use prices together with bilateral contracts. Again, think of the mobile ecosystem, negotiations, sometimes rather than secrecy, and they may rely on platforms. And there is a very recent account of a legal effort to integrate the concept of ecosystem into law in the paper I've cited by Lenos, Klasseller, and Kleischmann that I was reading over the weekend in preparation for this discussion, that I found very helpful in sort of framing the debate. Let me move to my next slide. Now, competition law has certain limits in dealing with this novel concept. The neoclassical price-inspired theory of competition law cannot adequately account for a multidimensional concept of economic power. Competition law looks at issues of the relevant market. It focuses on specific types of conduct. So when a competition authority deals with a case, it's trying to engage in a sort of categorical thinking and somehow, within the existing taxonomy of abuses, try to fit and develop a sort of a theory of harm that fits an existing type of business context. But there is a slow awakening, let's say, of the beast here being this new concept that is very difficult to tame. And there is indeed some acknowledgement that power can be exercised at an ecosystemic level, right? When it leverages an actor of the ecosystem, its power from bottlenecks to other more competitive spaces. And we see the effort in various legislative efforts to regulate ex ante the power of big tech, strategic market status in the UK, conglomerate market power, intermediation power in the EC report, and gatekeeper. So all these are efforts in order to address this awareness that power can be exercised not only on the level of a relevant market, but at an ecosystemic level. Nevertheless, as Lenos highlights, the concept of ecosystem in competition law is quite underdeveloped, but we see most prominently in the European Commission revised market definition, a first attempt, and Nicola referred to it in the introduction, to define a digital ecosystem. So what do we have so far? We have the revised in terms of sort of soft law, right, market definition, and the court being very, very proactive and having the sort of the first mover advantage in this sphere in the Google Android decision, the General Court, when it had to examine the intensity of the inter-ecosystem competition between the Apple and Google. There's a duopoly, right, in mobile ecosystems. And the court said quite explicitly that ecosystem is distinct from relevant market, right? And it laid down the foundations of thinking a bit differently when we deal with ecosystems. So it said in paragraph 116, and it is worth repeating it, that a digital ecosystem brings together several categories of supplier customers and causes them to interact within a platform. The products or services which form part of the relevant markets that make up that ecosystem may overlap or may be connected to each other on their basis of their horizontal or vertical complementarity. Taken together, the relevant markets may also have a global dimension in the light of the system that brings its components together and of any competitive constraints within that system or other systems. So the court said we need to start thinking of ways to assess inter-ecosystem and intra-ecosystem competition. It was the first judicial pronouncement we had. Now, the second important development, and I'm still staying at the EU level before moving to the UK, is the Booking It Travelly decision, right? That caught everyone by surprise, where the European Commission published in September the press release blocking Booking's holding acquisition of the Swedish firm Travelly. Now, the decision has not yet been published, but it's believed to be the first merger prohibition on the grounds of an ecosystem theory of harm in the digital space. So here the Commission considers that whether this competitive harm arises from the acquisition of complementary services in digital markets may not be confined to this distinct category of abuse we have, bundling or tying. This is something bigger, right? They're lying ahead than simply bundling or tying. So the Commission says that in some cases we may find competitive harm in the simple aggregation by acquisition of a new service or a product to a platform's digital portfolio. This will happen if the addition of the acquired product in the ecosystem is found to raise entry barriers in one or more markets within the ecosystem. Now, Booking is dominant in the hotel services market and benefits from these indirect network effects. So the acquisition of a travel agent would have granted Booking's hotel a main customer acquisition channel. It would have expanded, the Commission says, Booking's travel services ecosystem. And the Commission also looked at consumer inertia, like will the consumer shop around or stay in the Booking platform and combine, air tickets with hotels, and so that you have a little bit of a foreclosure also theory of competing travel agents. It looked at the numerous cross-selling opportunities that exist, and concluded that this will reinforce network effects. It will increase barriers to entry and expansion, and it will result in higher costs for hotels and possibly for consumers. Now, Booking put forward several remedies, mostly to alleviate consumer inertia. It said that, well, I will show customers on the checkout page a choice screen for hotel offers from competing travel agents, online travel agents. And the Commission found that these remedies are quite insufficient because we don't know whether this ranking is sufficiently transparent. It would affect several cross-selling opportunities, and these commitments would be very difficult to monitor. So here the question from an academic perspective is, are we talking about a novel here theory of harm materializing? It is definitely a clear shift from the more traditional non-horizontal concerns of input foreclosure or leverage, but is it an adaptation of these theories of harm, or are we talking here, is the Commission going to put forward, and we'll see this when the decision is published, novel conditions and mechanisms for a theory of harm? And finally, to conclude, these are the cases in the UK and in the EU, based on my research, that somehow to a larger or lesser degree refer to an ecosystem theory of harm, or imply an ecosystem theory of harm, or perhaps they had it in mind before we even coined the term ecosystem in competition law. Google Fitbit, yes, standard foreclosure, but it looked at data combination by Google to extract rents from consumers in areas such as health insurance and employment. We had the data siloing remedy in place, but an ecosystem theory of harm is looming there at large. Meta Giphy in the UK prohibited. Inclusion here of Giphy's business into Meta's ecosystem, said the CMA, could have been used together with Meta's other assets to disadvantage rivals. Microsoft Activision here experimenting, and it mentions ecosystem as well. Here, the concern is that as a result of controlling a list of assets, cloud, Windows operating system, the games, as well as important content, Microsoft would be uniquely advantaged, right, as an orchestrator in this ecosystem at a critical time of pivoting towards new cloud gaming technology. So about its ability to dominate a nascent market. And there clearly mentions ecosystem. And finally, I think there would be much promise in developing this concept further if the Amazon iRobot case had been moved ahead. And here it is, both the UK and I should mention this in the slide, and the European Commission. The UK cleared this in phase 1. The Commission signaled its willingness to go into an in-depth investigation of the merger, phase 2, and in the end, the parties abandoned the merger, and could raise also ecosystem theories of harm. iRobot being part of Amazon's, let's also flying wheels business sort of development, whereby it's not only about concern about foreclosing competing manufacturers of smart vacuum cleaners or selling below cost, or in sort of or predation theories of or predatory pricing as a theory here, but about through the iRobot amassing large troves of data from our personal lives and integrating them into the Amazon's ecosystem with further opportunities to exploit and extract rents from consumers. So with this, I conclude my short overview of cases in the EU and the UK, with the final comment being that this is the concept has matured in the economics and business management literature the past 4 or 5 years, but it still needs time to adapt and translate into the legal context. And without case law and decisions, we can't say much of them at the time being, especially with the air booking, with the e-travel booking case. Thank you.
Thank you very much, Danny. Fantastic cross-jurisdictional overview. So yes, I should have mentioned you are based in the UK, but originally from Europe. So you brought both perspective, and thanks also for the reference to Ioannis Lianos, who is always with us when we talk about the ecosystem, and for your overview of the theoretical underpinning of the ecosystem theories, which is quite important. I think now we should also hear a little bit more about the practical implementation of solutions when it comes to ecosystems. So I would move to Maria Ioannidou. We are still in Europe, and so we would like to hear a perspective about the practical experience of the European Commission when dealing with digital platform ecosystems. We heard, that in Booking e-Travel, the Commission rejected the Booking's acquisition, considering insufficient the remedies that were being proposed to address the conglomerate concerns. Some parallels can also be drawn with Microsoft Activision. And I think, we understand that effective remedies is something that is needed as a core element in mergers, but also is a core element of the Digital Markets Act, which does not have substantive obligations on mergers. So the question arises of whether we should expect synergies or spillover effects between these two areas, so DMA or DMA-like regulation and merger control, when it comes to digital gatekeepers or digital platforms more broadly. And what is the benchmark for effective remedies in this regard? We will hear perspective about this from Maria Ioannidou. So Maria, welcome. Thank you very much for joining us. You have the floor.
Thank you very much, Nicolo, and I should thank the organizers on my part for the invitation. What I would like to cover very briefly, and Nicolo, feel free to jump in. I know I'm the last speaker during this session, so you can stop me anytime. I just want to offer, before I begin, something to follow up on something that Danny mentioned with respect to Booking e-Travel. And I think it's a sort of a comment which links to the notion of ecosystem and how this is treated in competition authorities' practice. So it seems that the Commission has indeed, the European Commission that is, has blocked Booking e-Travel on the basis of Booking expanding its travel services ecosystem, and the behavioral remedies offered not being sufficient enough to address Commission's concerns. So now we're trying to decipher at this point whether this is based on a sort of novel ecosystem-based theory of harm, or whether it's a sort of a traditional non-horizontal merger guidelines for closure. I don't have the answer to the question, but Booking has challenged the Commission decision, and the grounds of Booking's appeal have been published, and there is no mentioning of ecosystem there. So I don't know if that is a hint, whether the Commission has relied on more traditional approaches. And mind you, from an enforcer's perspective, I think this is the right thing to do because in effect, these decisions will be challenged and there are certain precedents. So you have to go incrementally. So what we see as a sort of background is that competition authorities, the EU Commission included, they are going in a more kind of interventionist way when it comes to ecosystem theories of harm, however they frame them in the decision, with the precedent of booking e-travel. The other point I would like to mention, since the introduction for myself was coming from the UK and the EU, just to offer some insight with respect to divergent approaches, if you like. So booking e-travel has been approved by the UK CMA phase 1. Same with Amazon iRobot. So there is a question, is this a divergent approaches? If you follow enforcers, what enforcers say, they say that these cases are different on the facts. So they are cautious to differentiate them based on the facts. But the UK CMA, even though it has been one of the most vocal authorities worldwide when it comes to ecosystems, and we see the notion of ecosystem being mentioned and developed in the merger guidelines, when it comes to those two cases where the Commission seems to have taken a more interventionist stance, they seem to go the other direction. So merger control is one of the tools that the Competition Authority has in its toolbox to address problems we have with relation to ecosystem power, however that is framed. Point one. Second point, perhaps they should make use of that. Why? Because what we have seen in abuse of dominance cases, so ex post competition law enforcement, and that's where I would like to focus my 7-minute intervention from now on, is that remedies so far have not been effective in addressing whatever theories of harm they have been framed, following usually a long enforcement period. So novel theories of harm, you can think here self-preferencing, and previous speakers have covered self-preferencing theories of harm, both in some of the BRICS jurisdictions, but I guess you're all familiar with the EU Google shopping case. But even in theories of harm that are not novel, and this is what the webinar may be about to some extent today, exclusivity tying, the fact that the problem we have with ecosystemic power, with platform power, with the particular characteristics of digital markets, is very difficult to frame a remedy that can address the problem identified. So even though you may have a theory of harm, do we have a matching remedy? Experience suggests that we don't. And there is a problem with speed of intervention in those markets. There is a problem with how you structure remedies, a problem with expertise within the authorities, a problem with monitoring. And this is why perhaps competition enforcers are kind of hinting towards a preference to structure remedies. And this was part of the Commission press release in the booking e-travel case. And there is also the issue of effectiveness, because what the problem we have with platform markets, where we have strong players building their own ecosystems, is that those markets have tipped, perhaps irreversibly. So at the time of intervention, those markets are very concentrated. What should competition remedies do? Should we opt somehow to infuse them with a more restorative element? That's a long discussion. The short answer here is yes. And the final point I would like to make as a sort of a background is that, by and large, policymakers, competition enforcers have agreed that competition law tools are not enough. And that's where you cue in additional regulation, such as the DMA in the EU and the Digital Markets Competition and Consumer Bill in the UK. So there is also an interplay with regulatory remedies. And with that in mind, we need to think more holistically about our remedial approaches to problems identified with respect to platform markets with large players building their own ecosystems. Now, the next slides are quite heavy in information, so I'm just going to browse through them. What I was trying, the reason I had the tables is just to make the point that by now we have a very, very large number of cases looking at different practices by GAFAM or FANG or GAMA, however you're going to call them, big tech players. And they are premised by and large on similar theories of harm. And they also, to some extent, share some common DNA attributes with DMA provisions. So I'm just going to use some examples to showcase the point that I want to make. So Google shopping case in the EU, a protracted investigation. It started in 2010. It was concluded in 2017 after 3 failed commitment attempts. Was the remedy effective? By now, by and large, everyone agrees that the remedy was not effective. So we need additional regulation. So part of the prescriptive obligations we find in the DMA, they address self-preferencing in ranking. Has Google complied with that? It seems that Google has not complied with that. And this is something for other jurisdictions also to take into account. It has been mentioned before that Google has, in South Africa, given a commitment to comply with the DMA. It seems that the measures that Google is suggesting to comply with Article 6.5 of the DMA are not enough. And this is why the Commission has opened a non-compliance investigation. Again, we can see the problem. Do we know what the solution is and how we can gear the system towards adopting more effective remedies? Another similar example of such an approach comes from Amazon Marketplace, which has been concluded by commitments in the EU, and the Commission again is contemplating, they're gathering intel whether they should start a non-compliance investigation against Amazon. Another interesting case is whether the suggested pay or consent model that Meta is putting forward to comply with Article 5 of the DMA, so the prohibition of combining personal data from different sources, which was at the core of the German Facebook case. Again, the Commission has opened a non-compliance investigation with the question, again, what should be here a remedy that is compliant with the DMA and therefore with the broader competition regulatory framework. Similar, and another example can come from a case from the EU that has been recently concluded with respect to the Apple ecosystem, the anti-steering provisions in particular. And I'm going to move very quickly to the slide, cautious of time here. So anti-steering rules, the decision was out 4th of March, 2024. To my knowledge, it's been one of the very few cases that the fine has been inflated more than $1 billion to increase deterrence, and it was complemented by a cease and desist order. And the question is, if you're Apple, you should somehow stop doing that. But what is the benchmark for Apple to do that, and how we can utilize intel from different sources as a competition authority to put in place an effective remedy? Okay, so a final point before going very quickly through some suggestions is the fact that if you think holistically, and I'm thinking here, booking it, travel, behavioral remedies were not enough. Merger was blocked. Okay, the AdTech, the Google AdTech case, which is ongoing, it's one of the very few cases, and I would like your views on that, to my knowledge at least. The Commission has signaled in the statement of objections already that the behavioral remedy may not be enough. And this is a good development because it's a way to seek views of different stakeholders earlier on in the process. So just very briefly to sum up the points I'm trying to make here, and going back to Nicolo's question on effectiveness of remedies, I think we need to think of the design of remedies earlier. So when you have an investigation about a potential infringement, already at the beginning, thinking the theory of harm, you should start pondering about, okay, if my theory of harm, if I collect the evidence, if I can build a theory of harm, what will be the remedy here? There is no point as a competition enforcer of having resources on something that cannot be fixed. So timing of intervention. You need to think about market testing remedies, maybe akin to merger control or market investigations, and this is the way the DMCC guidance in the UK is going. So testing remedies prior to implementation and try to involve as many stakeholders earlier on in the process in a model, responsive remodeling, which would be very interesting to hear your thoughts about. I think I'm right on 30 seconds, and I'm interested to hear your thoughts during the discussion. Thank you.
Yes, perfect timing. Thank you very much, Maria. This is a perfect segue, by the way, to the next. I think that in the interest of time, since we have only one question, I will incorporate that into this introductory remarks for the next speakers. I think you pointed out, the effectiveness of remedy as a key aspect, and this is only going to increase with the type of ex-ante regulation that is proposed or introduced in different countries. Now, going back to the BRICS and considering the potential of alternative approaches to dealing with digital platform and ecosystem, we have seen that there have been several cases trying to deal with the specificities of these forms of organization of economic activity, but the concept of ecosystem itself is still in search for a proper scientific definition and characterization. For this reason, I think it would be interesting to hear immediately the perspective of the BRICS Competition Center, who has engaged in pioneering research, highlighting the potential of applying the lessons from scientific disciplines like evolutionary biology and complexity science to shape the governance of these markets. So it would be interesting to hear an example of how this can inform regulators and policymakers that are interested to getting a tighter grip over the competitive landscape of digital platform ecosystems, including approving ex-ante or implementing ex-ante regulations. And I'll tie this to the question that was posed in the Q&A, which is, we've been talking about platforms, but what about artificial intelligence platforms? ChatGPT of the US is now almost the dominant AI platform in the world because of machine learning. And the more dominant AI, it will become the smarter AI, which would attract more users. So this question was posed by Jisuk Yang. Does this virtuous loop suggest that we need to intervene earlier on, as was suggested by Maria right now? So with that, I will leave the floor to Alexei and Elena. I don't know who should start the presentation, but thank you very much for joining us. The floor is yours.
Thank you very much, Nicole, and thanks for having us for this amazing workshop. And thanks, Jungta, Teresa, in particular, for inviting us. And that's a continuation of a discussion we started together back in December at the e-week, Jungta e-commerce week, organized offline in Geneva, where we had an opportunity to present this project already. And I think we try to kind of continue this work, and this project is a product of a multidisciplinary group of people representing both competition community and mathematicians, cybernetics, those who dealing with complex systems, huge field of science, complexity science, those who joining us from Institute of Applied System Analysis, and Yelena will continue this presentation, focusing more on this, scientific aspect of our work. In a nutshell, you are right, Nicola, and other colleagues were saying this already in their presentation, that it's a new beast, in competition sphere. It's called ecosystem, but nobody knows what is actually it represents. But businesses, they already accepted this, self-identification, and this identity already became part of their actual business strategy. So they call themselves ecosystems. So this is a part of reality you can't ignore. That's why competition authorities have to start thinking in a way how business thinks. And there is a lot of business literature, business strategy literature, which kind of covering this topic from business perspective. But very few competition authorities actually started to think about ecosystems as a new reality. Business always is super adaptive, and this complex adaptive system, dynamics which business represents, it's very difficult for competition authorities, for regulators to capture. It was like the case back in the days when first, so-called mother trust arrived to the business, landscape. And this mother trust standard was also very difficult to identify, to classify properly, and to make all those, regulatory applications, enforcement actions to be working against this particular phenomenon. So these ecosystems are representing this new phenomenon, new business reality, and this business reality is actually different in a way, as a pioneer of industrial business corporatist America, Henry Ford, was referring to himself and his business as a planned exercise. It's an enterprise which built on planning and proper execution of this plan. And the modern type of capitalists, digital capitalists, they think about themselves like Jack Ma famously put it, like a blind man, driving on a blind tiger. So they don't know what they're doing, but they're doing it super successfully. And this is a new reality which ecosystem organizers sometimes can't describe it properly. So they don't know where this value is generated, as Danny was putting nicely, that value created within ecosystem is larger than value created within different elements of this ecosystem, the digital ecosystem. So there is a source of synergy, there is a source of generating this value, which is beyond the control of organizers. But when we talk about regulation, when we talk about competition law, and that was also perfectly shown in previous presentations of all the participants, it's very difficult to find out a proper definition, find out proper remedy to deal with these ecosystem effects, because regulation is still super mechanistic in its application, in its design. So design of competition laws, competition policy in general is still stuck in so-called mechanistic trap because it was developed during the industrialist era. And we see that in many competition regimes, the concept of ecosystem finding a place here and there. Sometimes it's not a part of actual decisions, stare decisis, if you want. It's more like obiter dictum, just competition authorities here and there mentioning, okay, ecosystem it was or ecosystem it is, but who knows what actually to do about this. And they mainly still refer to traditional theories of harm, foreclosure and tying, whatever, bundling. So this type of, traditional theories, but very rarely they really base their decisions on ecosystem. But in some of the cases, we hear that ecosystem was the reason. Where does it lead us? It leads us to a further fragmentation of a global marketplace. And I think everyone remembers the promise of internet era, the promise of digital economy, that we would live in a single kind of global marketplace, which would be organized on similar premises, similar principles, similar rules. And then out of sudden, this marketplace became, first gardened, wall gardened areas, and then it becoming more and more fragmented because of different legal, political, geopolitical issues. But competition law is now increasing this fragmentation by addressing ecosystem phenomena from different type of perspectives. And it reminds me a little bit this, long, old Indian saying about those sages who were observing an elephant, from different angles, from different perspectives. And each of those sages was looking for a particular part of elephant and describing this part, although nobody was actually understanding that they deal with an elephant, what kind of phenomenon they were dealing with. So this is creating this type of, vicious circle of fragmentation, more application of competition law and policy on national or regional basis we see, and this application is specific, to certain national or regional circumstance. Digital platforms and ecosystems, they adapt to those, regulatory or competition applications, and they change their behavior on a global scale. So they kind of adapt to local circumstance, and so we're losing a global holistic behavior of those ecosystems. So competition law is now losing this kind of regulatory integrity for the global digital economy, which I don't think is a good story for building better functioning, more serving people interests, consumer interests, digital economy, digital platform. And I think we should recognize at a certain level that we do need, because of this, particular digital economy developments, a form of international awareness or international, agreement on how we deal with digital ecosystem, especially with this new, technological phenomena, as Nicole, you mentioned, AI development. AI is a pretty much global phenomenon. It does change industries all around the world. Doesn't matter whether you accept AI, legally or you do not. You try to block ChatGPT, but it does find a way. So we have to accept that in an environment we live, there is a natural environment and there is economic environment. Both do require some sort of a joint agreement or joint understanding or joint vision, at least shared vision, I would say, how we deal with this environment. We found a way to deal with natural environment, with climate, with biodiversity, with all those things together and promote, the shared vision in this field. But we didn't find a way yet, and we actually moving in even opposite direction. We didn't find a way yet to look at the phenomena in digital environment in the same manner. I think it's time for, and that's an ambition of the project, to bring in methodology for competition authority so that they can become, more like gardeners, more like participants of these ecosystems in their evolution, in their developing, rather than mechanics who treat economy in a way like they treated machines, when they want to fix it, repair it, change one part and substitute with another. And that's what our project is about. So to become a gardener, you have to first change your perception of things. You have to change the way you deal with phenomena surrounding you. And ecosystems, they are living organisms. They kind of, evolving from within. They have inner energy. They live in cycles. They live on cyclical, basis. They evolve. They born. They evolve. They transform. They become monopolists at a certain point, and then they die, and then this cycle continues. Like every living organism in surrounding us, and with human bodies or with natural ecosystem, we're used to see this, cyclical nature, cyclical developments. But with digital ecosystems, to a much less extent. If you look at the Android case, for instance, Android is a very good example of ecosystem development according to the cyclical, principles. Android was born as an open platform. It was developed by a group of enthusiasts. Then it was captured by Google, bought by Google, and Google kept for quite a while open nature of this ecosystem. It kept its openness, open source and everything, attracting developers, attracting customers with this openness. And then slowly but steadily it started to change this openness into closeness, starting to transform Android ecosystem into a closed proprietary platform. And then after it achieved this, after this proprietization of Android platform reached a moment when Google was ready to kind of harvest the results of this proprietization, they started to externalize all their efforts into the markets, sucking kind of resources from both developers, equipment manufacturers, and customers all around the world. And only at this point, when competition authority started to intervene. So competition authority intervened only at the last stage of the development of this cycle, when actually Google started to implement, or let's say harvest the outcomes and implement anti-competitive behavior in its classic industrial sense, but also harvesting, the benefits out of the previous periods of this cyclical development. And in Russia in 2015, we had a case against Android. It was the first case in the world, pioneering case in the world. I was working on this case on the side of the authority. And it was very nice case, very advanced case at the time. And we managed to prove that Google did violate, competition laws in its classical sense. But remedies which were imposed, they still kind of intended to relaunch the cycle. Kind of, to move the development of Android ecosystem back to the open stage. But this openness is very difficult to achieve, while, the development of this ecosystem goes only one way. You can't, put the path back to the tube. You can't really revert the development of life or revert the cycle of life. Similar case decided in European Union, and all those remedies imposed on Android in European Union in 2018 made the same mistake. Remedies imposed on Google in Android case, they were not understanding how this cycle works, how this development of ecosystems actually continues according to the logic of development of the digital ecosystem as a phenomenon, as a complex adaptive system, I would say. And Yelena will say a couple of words on this. Another nice case is the ride-hailing platforms. As I said, fragmentation led us to very different application competition was around the world to the similar phenomenon. And the only country which now tries to apply this type of holistic approach to regulation of ride-hailing platforms is Kazakhstan, and we proudly cooperate with the competition authority of Kazakhstan in the recent case, which was out this year. Early in January this year, it was out. In December, it was announced, and in January they publicized the case. It was against Yandex Taxi, Yandex Go platform, as it's called. And Yandex Go platform is a dominant ride-hailing platform in Kazakhstan. It's part of Yandex ecosystem, which is dominant in number of markets, digital markets in the region, in the Eurasian region. And in this decision, competition authorities of Kazakhstan tried to impose the remedies against Yandex platform, against Yandex taxi platform, in a way that those remedies would consider the nature and the logic of development of this platform. They were applying, ecosystemic approach, ecological approach to the development evolution of Yandex ecosystem. And just say a couple of words to finalize my part of our presentation, that we have introduced a kind of a model. Yeah, so I don't have much. Yeah, just 1 minute.
Oh, just that we have 2 minutes left for also Elena's presentation. We can extend it a bit, but we should wrap it up.
Okay, so I will skip the part which I think Elena covered more, and that's kind of our innovative part, where we bring in this new methodology, and this methodology helps better to adjust remedies to make them adaptive and really like capturing this nature of evolution of those digital ecosystems. And we tested these remedies. Kazakh competition authorities tested these remedies in this Yandex Go case, but we hope we can develop more. I will skip this, and just is the last slide of my presentation. This paper, which is multidisciplinary paper, we intend to publish in the Nature friendly journal, Nature Complexity journal, is out, so you can read more details on methodology. And with this, I give the floor to Yelena to mention just that November 22nd, together with Nicola, we're going to present this ecosystem eco-antitrust report, as we call it, in Rio de Janeiro. So stay tuned, and please come to Rio de Janeiro. So now I give pass forward to Elena with her presentation.
Indeed, we confirm that invitation and pass the floor to Elena. Elena, can you complement? Do you want to complement what has been said?
I will say a few words and try to be as quick as I can. Just a second. Yeah, I think what we really wanted to convey in this presentation is that this idea of calling ecosystems has something really bigger than just a word. And that's basically what our research is all about. And we don't have time today to discuss this in details, but basically when James Moore called these networked businesses ecosystems, it's not just a term. Yeah. So what really happens is that these two types of systems, so digital ecosystems and natural ecosystems, where the term comes from, they really share some basic characteristics which are not so trivial, and that are not many systems, or let's say not all systems actually have. So they are complex systems and they are adaptive systems. That's this model that is used in ecology that is called complex adaptive systems. And the systems, as you can see here, very kind of sketchy, consist of multiple agents. This was mentioned by previous speakers, that the main idea of ecosystems is the value co-creation by multiple agents. So that's basically what these complex adaptive systems are about. So you have multiple agents interacting here, and that gives rise to a so-called macro level patterns, behaviors, or properties. And that is really what distinguishes this kind of systems from mechanistic systems. And it's important to understand it. And our main proposition so far is that because of that theory that actually underlies both digital systems and natural ecosystems, we can in fact learn from nature and transfer some of the mechanisms and some of the insights that biology and ecology accumulated over there in order to see the pathways of harm. So the new theories of harm were mentioned earlier. So what is the source of new theories of harm? This could be those phenomena that we observe in nature. And the same for remedies. We could learn from nature, and we can learn from our own experience how we manage natural ecosystems, and we can see what are the main principles that are applied there that are effective, and we can transfer them. And the main idea is, once again, I repeat, that it's really because of this theoretical foundation that exists between these two systems. And that's why we are suggesting that. And again, it was discussed by other speakers already that the innovation is very important part of success of digital platform ecosystems. And that's again, where the process of innovation really resembles what we observe in nature, which is evolution, of course, through mutation and retention of new properties. So what would this mean to adopt the ecological approach? And that's what Alexei tried to explain. So first of all, it's really adopting the ecological worldview. It's not something that one can explain in boxes and specify what it is exactly. It's the worldview that matters. And once one has the worldview, almost insights and conclusions, they follow. So they really follow from how we see the world. So how do we change the worldview, or how does it change by itself? Often it changes through the use of metaphors and concepts. And that's why we have the second layer, that we may want to adopt more concepts, more metaphors from nature to describe the digital system. So the term ecosystem has already been adopted. There has been also adopted, I will skip this, there has been adopted, of course, the term of keystone species or keystone element. So that's also coming from ecosystem. And as you can see, once we have adopted the certain term, with it already comes the conceptual understanding and sometimes also technical understanding, which means that when we transfer concepts and ideas from ecology, let's say, to business, to describing this kind of businesses, we can do it at the conceptual level, and we can also do it at the technical level. So here again comes the paper that Alexei already highlighted. I would invite you to look into this paper for new metaphors that we have suggested. So there are already a few suggested in literature, so we have suggested more. So you can, for example, see this picture, and even without knowing biology or ecology, you can maybe kind of guess what is on this picture, and doesn't it require killer acquisition that you all are dealing with? I think it does. So there are many phenomena in nature like this, which you already observe in digital systems, and we can learn from that. And finally, since we don't have time, my last slide, I mentioned the technical level. So beyond the adoption of new concepts, metaphors, we can also adopt specific modeling techniques in order to enrich the toolkit of the antitrust. So these are three main topics or main fields from which this adoption can happen. Complexity science was mentioned already, and network science. So that's, of course, because these businesses are network businesses. There is a wealth of knowledge in this field that could be used. Again, Ioannis Lianas and his colleagues already experiment with, for example, centrality indices, but much more can actually be taken from that field. Agent-based modeling is also another area that is rapidly developing. I'm sure you all heard about it. And finally, evolutionary game theory. So that's again how we can model innovation through mimicking the evolutionary process of mutation, selection, and retention. So these are, I would say, the three concrete areas we are experimenting with. We don't have time to show you any results today, but if you are interested offline, I'm happy to speak about it more and discuss any questions you may have. Thank you.
Thank you very much, Elena. This was very insightful, and I think it shows that we can borrow from other disciplines. I mean, on the one hand, they can provide some tools, but on the other hand, they also cannot provide a definitive answer on these questions. You say also innovation is a matter of trial and error, but also regulation is a matter of trial and error. And I think it has come out in some of the presentation as well. So I think that it's been an extremely rich discussion. We had a number of interesting reflections and provocations. So unfortunately, we don't have time for really Q&A, but I wanted to leave the word, for the final round. The organizer told me we have a few minutes of flexibility, so we can hear from you basically on your reflections. And also, what my personal question would be, what are the prospects of harmonizing the approaches across jurisdictions? And particularly since we are at UNCTAD thinking about the characteristics of developing countries, should they adopt a different type of approach? And are these differences between countries, and particularly focusing on developing countries, more pronounced or less pronounced when it comes to devising ex-ante regulation, as we have been seeing cropping up in various places all over the world? So I would go back to the first speaker and leave to each of you a couple of minutes for your remarks, and then we can close the webinar. So Victor, back to you, back in Brazil.
Thank you. Thank you, Nicolo. I know that we are a little bit ahead of our schedule, but I think that there are some interesting updates from Brazil that I would like to share regarding the discussion on ex-ante regulations. So in Brazil, we actually have a first proposal of ex-ante regulation, which was submitted before the National Congress in the end of 2022. But this proposal is rendered problematic for several reasons. Especially, I think, in my personal view, that this most problematic aspect of this legislation is that this proposal approaches competition in digital markets through the lens of a public utility regulation. For instance, the proposal assigns the power to adopt this legislation to the telecommunication regulator instead of the competition authority, for instance. And because of these problems, in the beginning of this year, 2024, the Ministry of Finance in Brazil opened a new public consultation to gather inputs from society on new forms of ex-ante regulation for digital platforms. And in the context of this public consultation, CADE has prepared a very detailed 60 pages submission and providing its perspective, its new perspective as a national competition authority in Brazil. And this document was made publicly available in last May, so it's a very fresh document. And for the very first time, CADE has sustained that it is necessary the adoption of a new ex-ante regulation in Brazil in order to complement our current competition law regime. And it's very interesting to notice, for instance, that in its submissions, CADE has especially acknowledged some insights from the ecosystem theory of competition, which was touched by Professor Montrazi and Professor Alexei before. For instance, CADE has stated in the submission that the new ex-ante legislation should address not only market failures, but rather ecosystem failures, which consist in functional and distributive failures in the generation and capture of value by complementers and gatekeepers. So CADE has especially embraced this theory, and CADE has quoted works from Professor Jonas Lianas that we have mentioned before, from Professor Carmelo Semano, for instance. So CADE has pointed out that we should adopt an ex-ante regulation in Brazil, having in mind this insights from the ecosystem competition theories. So with this response from CADE, and it's very, very important landmark for the discussion of ex-ante regulation in Brazil. In the next few months, the Ministry of Finance is expected to prepare a comprehensive report on this topic and eventually propose new alternatives of ex-ante legislation to the National Congress. So we are following very closely these new steps, and maybe this debate is going to get bigger in Brazil in the next upcoming months.
Thank you, Victor. This was a very important developments to share, and very good to see that ecosystem theory is getting some traction in the development of ex-ante regulation, hopefully. But so I think that can be something that unites the discussions among all these countries that are thinking hard about a new framework. So it's very positive to see that development. Now moving over to Harry to see if you have, Harry, anything to share with us as final words.
Thanks, Nicolo. I think the harmonizing point that you raise is quite important, and the earlier presentations also talked about the ecosystem as a theories of harm, and also as spoken by Denny, and the remedial action, how earlier should the remedies to be competition authorities to reach out to the affected parties in order to provide them sufficient time to engage and also to arrive at implementable and enforceable remedies. And the third point is DMA-like setup the way forward? It comes with an implication of finance and human resource, even the skill resource. Not every jurisdictions or every country will be able to implement similar to what DMA has done, but is that the way forward? We're not sure. But harmonization of regulation, especially the ex-ante one, is a way forward. Thank you.
Thank you very much, Harry. And of course, and your authority has been a leader in creating this kind of regulation through the market investigation, market inquiry tool. I think that's very promising to look at possible ways to deal with these challenges. Now, I will move to Japan. Masako, what are your reflections after hearing all these presentations and remarks?
Oh, well, simply put, I would agree. And I would like to see the harmonization of the ex-ante regulation in particular. Thank you.
Excellent. So +1 for harmonization. Very good. Now, let's see from the UK, Europe perspective, if there's any insights on the basis of what has been discussed here, maybe starting with Denny.
So being, in the UK, I have to defend going my own way, as the UK is trying to do post-Brexit. So I think that although we have a consensus emerging that, existing competition laws are not sufficient to address the anti-competitive conduct we see in the digital economy, I think we have varying degrees of consensus on whether an ex-ante regulatory framework is necessary to complement these harms. And I wouldn't be so enthusiastic about convergence. I think they have, especially in developing countries, in some areas, based on my research, we have seen that there have been less concern with the power of the platform, some of the developing countries, but they may be also more dependent of them. So I would say instead of convergence and absolute consistency in regulation towards digital platforms around the world, maybe we need to enhance regulatory coherence, and initiatives such as that of UNCTAD Research Partnership and the discussion we're having today is a way to promote some regulatory coherence, but not absolute consistency, as I don't think there is a one-size-fits-all approach in this context, especially looking at the perceptions that developing countries have on digital platforms and the ways their economy, right, interacts with these platforms.
Absolutely. So harmonization doesn't mean one size fits all. It's more about having the same tools and understanding, but maybe addressing in a different manner, as the UK does with their own type of ex-ante regulation, for instance. And now, Maria, what about your perspective, considering all that has been said, and your take on remedies?
Yeah. So very briefly, just to wrap up what's been said, and I would like to end on a positive note. So harmonization, the way I see it, you can see it on 3 levels. And by and large, there is agreement worldwide when it comes to the first level, policy discussions. So we need to do something, and we by and large identify the same problems, including China here, that have different ecosystems and different players. So the underlying problems by and large will agree, and that we need to do something. So there is harmonization at the level of policy discussions. The more, as you move up the pyramid, if you like, there is less so when it comes to harmonization in competition law enforcement and regulation. So we all agree that, for example, let's take the regulation. DMA and the MCC, just to use the EU-UK example. We agree on the problems, different approaches. Is that a bad thing? Not necessarily, because regulatory experimentation, as you mentioned, is needed. But there is, to some extent, harmonization. And I use juxtaposition here, law in books and law in action. The law in books is by and large harmonized, law in action not so much. And the proposal, just to link it with remedies, what can be done going forward. We have had cases in Europe, and I'm thinking here the early German Amazon case, which ended with commitments, and also the French Google AdTech case, if I'm not mistaken, that national competition authorities, they managed to secure remedies that applied worldwide. So perhaps this is something that we need to ponder more on the remedies that we managed to get from those big players. And there is also, alongside normal cooperation in merger cases and so on and so forth. But as a sort of a proposal, I think local cases could result in global remedies, and that's something we may experiment more on.
I like that positive
Thank you very much for coordination. This is part of the regulatory coherence, right? To have a discussion early on remedies. I absolutely agree with Maria on that. And it's one of the proposals we put forward back in November at the e-commerce week. Yeah.
Great point. And we see also in the South African inquiries, as a remedy that was proposed, it was indeed to expand the implementation of the DMA, for example, in South Africa. So we already see that being implemented.
The problem is that the Commission doesn't feel that the DMA is being complied with on that front. But yeah.
Let's see. Law in action is always important.
Yeah.
But for that, we also need to have regulatory capacity to deal with all this. So maybe asking as a final intervention to the BRICS Competition Law and Policy Center and IASA, if they see that regulators would be equipped to apply this framework, if this framework that they are proposing would be something that could be embraced by regulators, or they need some extra steps, extra capacity to understand complexity science, for instance.
Thanks, Nicole. Yeah, I think regulators definitely would need extra capacity. That's sort of obvious, but I will try to stick with our metaphor with environment. And I'm not a big fan of ex-ante regulation, to be honest, because ex-ante regulation is it really depends on ability of the country to enforce. We already see, even in the European case, that the European Union, huge economic entity, does have a lot of issues with proper enforcement of this, regulations against those huge giants, mainly American, with one exception, one company from BRICS. And with smaller countries, you have a lot of environmental laws which prescribe, certain rules for global corporations, oil or cocoa producers, and they just don't comply. They just don't comply, and it's super difficult to make them to comply. Just because negotiating powers and disparity, in negotiation powers is huge. So that's why I think much more opportunity for countries like developing countries, those which joined BRICS recently, because BRICS is enlarging, as you know, and is laying in a field of joint enforcement actions, joint remedies, joint investigations, joint reviews, because that's how you basically level playing field. That's how you balance, bargaining power against global giants. And if you make a decision in a way, we clear this merger, but only if you comply with this and this requirements in all our jurisdictions, not in selected ones, yeah? If you kind of ban strategic maneuvering, strategic filing type of things, that you can achieve something. Then you can, Danny was saying that in many developing countries, regulators are less concerned about giants, digital giants, but they are more damaged by their presence. This is one of those, let's say, strange kind of, conclusion, but it's reality, yeah? So it is reality on the ground, because they know that they can't really make those giants to comply with certain rules. So the way to go forward is to allow competition authorities to join their forces. And we know that the global competition project failed, both at the UN level with Havana Charter to be abolished, and WTO. WTO didn't incorporate competition regime. So the only thing we're left with is some form of regional or super regional, like BRICS format of cooperation, when we can really impose some terms and conditions on global corporations, which present in all parts of the world. I think if, for instance, BRICS authorities jointly start to investigate Microsoft OpenAI agreement, that would be a case to negotiate or to discuss at least more inclusive way of development of AI. Things like this, I think, more important than ex-ante rules, which would be just copy-pasted all around the world and not really enforced because of the lack of this negotiating power. That's my take on it.
Interesting take. Thank you. Elena, do you want to add anything?
Yeah, just a couple of words, again, using another comparison, let's say. So after the financial crisis of 2008, there was a lot of discussion why it happened and what kind of characteristics made it possible that such huge financial systems that seem to be very stable actually were not so stable. And there was a lot of research into that. And in fact, for UK colleagues, maybe you're aware, so Bank of England, in fact, led some of that research and concluded that that was because of the, again, conceptual understanding of those systems as robust and as systems that one can manage. And for these three domains that I presented in my last slides, complexity science, agent-based modeling, and evolutionary game theory, these were exactly those three sort of domains of knowledge and source of models that experts concluded we should be using more in financial systems. And since then, in fact, that has become almost the mainstream. So it's been now, what, 15 years. And so in that part of the economy, actually, this paradigm shift has happened already. And what triggered it was the financial crisis. Yeah. But the question is, do you need to have a similar crisis of a similar scale with in this field that you are dealing with in order to make that paradigm shift, or we can do it without the crisis? So I guess we would prefer to do it without the crisis. And maybe we can learn then from experience of financial markets and use those theories and use those tools that now have been made available. That's my understanding and suggestion. Thank you.
Absolutely, absolutely. And I think there's a lot to learn in other regulations and the regulatory process, especially that is followed, which involves some revision and monitoring over time. But I mean, I think you will agree with me, there's been a lot of very rich and interesting contributions, food for thought for policymakers here. And I want to also end on an invite that was already mentioned by Alexei. We will continue this discussion on ecosystems on the 21st and 22nd of November at in Rio de Janeiro at FGV Law School. So you will see the announcement soon, and you will be able to participate online. So hopefully we will see you there. And I want also to thank everybody and pass the floor actually for the final closing to Sung Kim. Pardon me if I don't know exactly how to pronounce, but who will represent the competition and consumer branch of UNCTAD in giving a formal closing to the webinar. So thank you very much, everybody, and you have the floor.
Thank you, Nicolo, and thank you all joining today's webinar. I'd like to express my gratitude on behalf of Ms. Teresa Moreira from UN Trade and Development, who unfortunately cannot be here with us now due to other commitments. We hope you find the session informative and engaging. Above all, I'd like to extend a thank you to our co-host, the Competition Authority of Brazil, CASI, the BRICS Competition Law and Policy Center, and FGV Law. I also deeply appreciate distinguished speakers for sharing your valuable insights and expertise. Your contributions have made this session so worthwhile. Our speakers demonstrated competition law enforcement and policy developments in BRICS countries, as well as other jurisdictions and continents, including various attempts to establish theories of harm to properly analyze the impact on competition in the digital ecosystem, not only from competition authorities' perspectives, but from academic perspectives. I believe that this active exchange of opinions will greatly help ensure that the development of digital market contributes to the inclusive growth of the global economy. As a kind reminder, I would like to draw your attention again for UN Trade and Development's IGE meeting in July, which will also feature a session on enforcing competition law in digital markets and ecosystems. We look forward to your participation. Thank you once again for your active participation and engagement. Have a great day. Thank you.
Thank you very much to everybody.
Thank you, everybody.
Thank you, everybody.